नमस्कार, आई एम संजय चतुर्वेदी। सोसाइटी मित्र के 9वें पॉडकास्ट एपिसोड में आपका स्वागत है। सोसाइटी मित्र एक बहुत बड़ा यू कैन से जजमेंट्स की एक बड़ा खजाना है आपके लिए, जिसमें से मैं चुन चुन के एक एक लैंडमार्क जजमेंट्स आपके लिए लेके आता हूँ। आज की कड़ी में मैं दो प्रमुख विषयों के ऊपर बात करूंगा। जो एक लैंडमार्क जजमेंट आया था उसी में दोनों समाहित हैं। एक तो पार्किंग, जो सोसाइटीज़ यूजुअली जो पार्किंग ट्रांसफ़र करती है, बिल्डर से लेती है, तो उसकी क्या एग्जैक्टली प्रोसीजर है और उसको हु इज़ प्रोगेटिव इट इज़ दैट वेयर टू ट्रांसफ़र एंड हाउ टू ट्रांसफ़र। और दूसरी बात, जब भी एक बहुत बड़ी समस्या ये आई है कि यूजुअली एक सोसाइटीज़ की जो फेडरेशन होती है, उस फेडरेशन को जब बिल्डर पसंद नहीं आता है या बिल्डर के साथ झगड़ा हो जाता है रीडेवलपमेंट के लिए, तो जो फेडरेशन कहती है कि भाई हमको अब आप एक काम करते हैं, हम बाइफरकेट कर लेते हैं सोसाइटी को और फेडरेशन को, और इंडिविजुअल सोसाइटीज़ अपने आप अपनी रीडेवलपमेंट करेंगी और हम जो है आर्बिट्रेशन में लड़ते रहेंगे। एक नई ट्रेंड शुरू हो गई है। अब जो इंडिविजुअल सोसाइटीज़ हैं, अनलेस दे हैव अ कन्वेंस, हाउ कैन दे गो फॉर द रीडेवलपमेंट। और जो लार्जर लेआउट में जब फेडरेशन के पास में कन्वेंस होता है, या जब भी बिल्डर लार्जर लेआउट को कन्वेंस देता है, या स्टिल उसके पास में कुछ अभी जैसे कि उसने कुछ बना दिए हैं, आउट ऑफ से 10 बिल्डिंग उसने 8 बिल्डिंग बना दिए हैं, 2 बिल्डिंग अभी भी बाकी है, तो क्या वो कन्वेंस इंडिविजुअल सोसाइटी को देगा या फेडरेशन को देगा? इसी से मुतल्लिक एक बड़ा वीपी कोलावा, जस्टिस वीपी कोलावाला का एक जजमेंट था बॉम्बे हाई कोर्ट का, जो 30 जुलाई 2019 को प्रोनाउंस हुआ था, जिसमें मैराथन ईरा कोऑपरेटिव हाउसिंग सोसाइटी का ये एक लैंडमार्क जजमेंट है बॉम्बे हाई कोर्ट का। मैं आपके लिए कुछ एक आध दो पैराग्राफ्स पढ़ूंगा, पर उसमें समस्या क्या थी। Then it will be open to the plaintiff society to effect transfer of the parking along with the transfer of the respective flats to the respective transferees. अगर मतलब जो पार्किंग होती है वो यूजुअली इट्स अ एमिनिटी टू द फ्लैट। बहुत सारी सोसाइटीज़ में ऐसा भी देखा गया है कि टेनेंट्स को भी पार्किंग नहीं करने देते हैं। लेकिन मैं आपको बताऊं, जो पार्किंग होती है वो यूजुअली फ्लैट्स के साथ में एज ए एमिनिटी आती है, तो यू कैन नॉट डिटैच द एमिनिटी फ्रॉम द फ्लैट। यू आर टेकिंग अ नॉन ऑक्यूपेंसी चार्जेस, सो you just can't refuse the parking to the tenants in the society first. Now in this particular landmark judgment, what had happened was that I'll just read what is the fact and then we'll go directly in the judgment. The fact is that where it has challenged the order passed by the competent authority under the Maharashtra ownership, that is MOFA, rejecting the application of the plaintiff for a deemed conveyance in respect of a certain portion of the land forming part of the larger layout on which the plaintiff building is situated. That means the society's building is situated. बिल्डर ने काफ़ी बड़ा लेआउट था बनाया था, पर सोसाइटी वॉज आस्किंग द कन्वेंस ऑफ द एंटायर थिंग विच द एंड अनलेस देयर इज अ कन्वेंस द सोसाइटी, यू जस्ट कांट गो फॉर द रीडेवलपमेंट ऑल्सो. So what the Honorable High Court has opined, I'll just read for one paragraph for you. It's a landmark judgment and touching almost many problems as far as the redevelopment of the societies are concerned. So the order says, a substantial number of car parking spaces have been allotted by the defendant number one, that is the society, by the builder, being the developer of the aforesaid building, comprising of 4 wings, prior to the registration of the plaintiff society. So a developer has already allotted some parking. Insofar as those car parking spaces are concerned, it will be open to the plaintiff society to effect transfer of the same along with the transfer of the respective flats to the respective transferee. Now I have just remind you one landmark judgment of Nihal Chand Laluchand, where it is very clearly have said that the car parking cannot be sold and purchased in the housing societies. So now with reference to this, then again I am coming back on the operative part of the order. Honorable Court in paragraph B of that operative part, it says, pursuant to the car parking policy adopted by the plaintiff has given details of parking space allotted by them in Exhibit 9 of the affidavit of the plaintiff dated so and so, filed in the above notice of motion. As far as these car parking space are concerned, the plaintiff society shall be entitled to accept changes in respect of the said car parking spaces, including re-allotment or surrender by the present member who are mentioned in Exhibit 9 of the affidavit of the plaintiff dated so and so. In the third paragraph of the operative part, it says, the plaintiff society and defendant number 1 shall not allot any further car parking space on and from the date of this order. However, it is clarified that it will be open to the plaintiff society to use the balance car parking space for the purpose of the visitors car parking and for no other. As far as the visitors car parking, there is a specific provision in the DCPR that you have to keep some visitors car parking reserved. This maybe it is not now right now enforced, but once it is enforced, the societies have to vacate those visitors car parking. Now coming on the fourth paragraph of the operative part. As far as car parking space which have been allotted to defendant number 2 to 4 in the suit number so and so, so and so, so and so, and defendant number so and so in suit number so and so are concerned, the aforesaid defendant shall not sell alternate part of the possession and so and so, so and so, so and so. There are some restrictions on this. It is made clear that this order is only a pro tem arrangement pending the decision in the writ petition so and so, and is strictly without prejudice to the right and contention of all the parties in the order and shall not be treated as this. So the ruling in this particular judgment was that it will be open to the plaintiff society to effect transfer of the same along with the transfer of the flat to the respective transferee. There was a claim of the society for open spaces where the car parking was reserved, and that too was under the deemed conveyance. They were denied, and this was the writ actually in the honorable order. In this order we got two ruling. One is that the federation, usually right now what I see is a fashion that federation frustrated with the developer, what they see is that they just bifurcate the federation or liquidate the federation and ask their member society to please go ahead with their own redevelopment first, just to deviate. Because see, the outgoing developer will definitely going to challenge that termination of the development agreement, and to just save the litigation, the bifurcation of the federation is right now mooted by the many federations. But what will happen, because the plot of the federation is not subdivided, and unless the society is having a conveyance, it cannot go in the redevelopment mode. Now these are the technical hitch. In this particular judgment of the Honorable Bombay High Court, the deemed conveyance was also denied when the society was actually asking that open spaces which was kept for some parking or open parking or maybe some other purposes by the developer who has not handed over the conveyance to the federation, and that time the member society was asking the parking open spaces for this. Honorable Bombay High Court have actually allowed them to do the visitors car parking, but then it was categorically denied. The second take from this particular judgment was that when you transfer a flat, you cannot detach a car parking from the flat, because the parking is an amenity to the flat. So you just can't say that okay, we are going to transfer the flat and then we are not going to give you the parking. parking has to be transferred to the this. In this, I have also cited two rulings. One is that the car parking cannot be sold or purchased, and the second is that the tenants cannot be restricted to park their vehicle in the society. With this, I believe that we are having a plethora of other judgments on the car parking. Whether the car parking, if it is illegally sold by the developer, if it is not sold or purchased, then can the society now ratify that? Bombay High Court have already had one landmark judgment on this. Then can the society ratify the mistakes done by the developer? Or there are many other car parking landmark judgments were given in this context. Short of time, you can always go and subscribe the Society Mitr. Society Mitr is basically एक खजाना है लैंडमार्क जजमेंट्स का, कंपाइलेशंस है, और उसको हर दिन हम लोग उसको अपडेट करते रहते हैं. जब भी अभी आपके पास में सोसाइटी की कुछ समस्या है तो आप उस लैंडमार्क जजमेंट्स को उस समस्या को आप सर्च कीजिए. लैंडमार्क जजमेंट्स होता है, रूलिंग्स होती है, बिकॉज एक्ट जो होती है वो इंटरप्रिटेशंस होती है. आप और मैं आपस में बहस करके उस इंटरप्रिटेशन, मैं कुछ और बोलूँगा, आप कुछ और बोलेंगे. इससे अच्छा है कि जो कोर्ट ने इंटरप्रेट किया है, जो उसके ऊपर लैंडमार्क जजमेंट्स दिए हुए हैं, उसी रूलिंग को वो होता है. इसी से हमारी लिटिगेशन भी बच जाती है. यदि हमको रूल मालूम है तो मालूम है, जो रूल है, तो यू कांट से दैट ओके वी आर above the courts or above any other rulings. You have to obey the court's ruling, and that is what the landmark judgments can play in any of the debate which the society is right now going ahead with this. Many other things which going to come in the Society Mitr next episodes. Be with me. मैं आपका होस्ट संजय चतुर्वेदी अगले रविवार 11 बजे फिर से हाजिर हूँगा एक नई लैंडमार्क जजमेंट को लेके. यदि आपके पास कोई सुझाव है, प्रश्न है, तो आप चैट बॉक्स में या editor@saptakala.com पर मुझको लिख सकते हैं. धन्यवाद.